We want to get into the closing argument of the Daniel Riley trial, where there's a young lady named Janae Edmondson, lost her legs at the age of 17 in a car accident that she didn't have no kind of tribute to it, but young man was found guilty. But this is a closing argument.
Thank you. Good afternoon. You've heard all the evidence. This case is about choices. This case is about the series of choices that Daniel Riley made on February 18th, 2020. Let's start with those choices. First of all, we know from the evidence he did not have a driver's license. He never had a driver's license.
Mm.
Yet, he drove a car that his mother rented, this Audi 5, knowing he didn't have a driver's license. Why do you need a driver's license? So you know how to safely operate a motor vehicle? So that you understand the rules of the road? So that you know what the signage means? You understand the dangers of driving a motor vehicle can have on other drivers and pedestrians? He didn't have that. He didn't have a driver's license. He never even passed the minimum requirements to have the privilege to drive in the state of Missouri, right? It's not granted that you can drive a vehicle safely. That's number one. Number two, we've got him speeding, right? We know that he got from 0 to 45 miles per hour on St. Charles, which, as you heard from Mr. Eckridge, who lives on that street, it's essentially an alleyway, okay? It's a one-way street. There are parked cars, okay? 0 to 45 miles per hour in 5 seconds. That's a choice. You saw on Tom Morris's, you heard from his testimony, and you saw on the gauges that were represented. That Audi is being 100%. That's a choice. Now we know that about a half a second before he approached the yield sign, took his foot off the gas for half a second. And then what did he do? Back down, pedal to the metal. And you know what? He had a yield sign. Why? Because it's a thoroughfare, right?
Mm-hmm.
There's other cars coming. The yield sign is, hey, slow down or stop. Be careful. Make sure you can safely enter this intersection. Did he do that? No. He didn't even yield. That's a choice. He just blew through it. It's a choice. What else do we know? We know from his blood draw that he had fentanyl, which the toxicologist testified can cause divided intention, such as driving, right? Your ability to react quickly, which you have to do when you're driving a car. He also had codeine in his system.
Mm.
And an effect of codeine is drowsiness and confusion. Okay? That's how he's operating that vehicle that night. for any other people that were around that night. And we know through every witness that testified, it was busy downtown. It was Saturday of Mardi Gras. There were sports tournaments downtown. There were people on foot everywhere. And he's blowing through an intersection between Tom Morris told you that the speed at impact, the low end was 42.1 miles per hour, and the range at the high end was 66.9 miles per hour. Okay? That was a choice. That was a choice. What do we know? We know that you've got the young ladies, Ms. Gorman and Ms. Smith, and they're driving along in this white Chevy Impala, okay? They don't have any traffic signals telling them or notifying them that, hey, we need to yield or we need to stop here. They're following the rules of the road. They have the right of way, correct? They have the right of way. Because of his speed, they never saw him coming. He came out like a bat out of hell, like Mr. Whittington told you. He was hauling ass. They didn't even have time to react. They didn't even see him coming. So, yeah, technically they hit him, but that doesn't mean that they are the ones who caused that collision. It was the defendant's actions that caused that collision. And as a result of that collision, he flipped over, and what happened? He crushed Janae Edmondson's legs between his vehicle and the parked car as she was trying to run to safety. Crushed her legs. That's what happened here. And this is serious. Because I tell you what, but for this belt and the quick actions of her father, James, and Janae's will to live so she could see her parents again, and but for the grace of God, we would be here on a homicide today. Not because of anything he did or didn't do, but because of other people that reacted quickly. And a miracle, honestly. Now, I wanted to talk to you about the defendant's demeanor at the scene, okay? You saw some of the officers testify very emotionally. People who had, you heard from Officer Chop. He's and because of his actions, she now has no legs. She's suffering the consequences of the defendant's actions. And you know what she's doing? She's persevering. She's doing everything she can to continue to have the best life. Not because...
Excuse me, y'all. I have to say this. A volleyball player. They was at their tournament downtown where they live, and they were leaving the tournament. And God, y'all, she would never thought that she would lose her legs. She didn't know why she couldn't move. This testimony, I'm not going to tell you what happened to the young man in this case.
She's angry, but because she wants to move forward and she wants to have the best life possible. Consequences. That's she's in the prime of her life. She was 17
17.
when this happened. It's tragic.
Mm.
And it's due to the defendant's actions. No doubt about it. Now, I want to talk to you about the instructions in this case. I'm going to go ahead. The judge read you the instructions. Probably didn't make a whole lot of sense to you when he's reading it, but we're going to post them up here on the screen so that I can go through them with you to help you understand them. Okay? Instruction number 5 relates to count 1, which is assault in the second degree. Okay? So this is the law. I'm sorry, Mr. Deemer, can you move your bottle? Thank you. This is the instruction for assault in the second degree. And these are the elements. Okay? These are here in the city of St. Louis. Serious physical injury to Janae Edmondson by causing a collision in which she was struck. Okay? Mm-hmm. So we've got some legal definitions there. First, let's get to recklessly. Okay. That paragraph there that starts, a person acts recklessly as to causing serious physical injury if the person consciously disregards a substantial and unjustifiable risk that his conduct will result in serious physical injury, and that disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in the situation. So how would a reasonable person have been driving down St. Charles Street under those circumstances? And ask yourself, and I submit to you, the defendant did not act reasonably.
Yeah, that's their technology.
It was a joyride. He had a fancy car, and he was being a hotshot that night, without regard to anyone else in the area. So reckless conduct, speeding, violating the yield sign.
Excuse me. They ain't have no license.
And not having a driver's license, more importantly. So now we need to find out through the definitions, what is serious physical injury, okay? Serious physical injury in the last paragraph. It means physical injury that creates a substantial risk of death or that causes serious disfigurement or protracted loss or impairment of the function of any part of the body. Check that box. There is no doubt that box has been checked. All right? When you read the instruction number 5, you're going to get some verdict forms, okay? One is going to be for guilty and one is going to be for not guilty. I submit to you, based on the evidence in this case, guilty is the verdict form you want to sign. Because the defendant clearly, beyond a reasonable doubt, acted recklessly when he caused her injuries. Okay? Let's move on now to instruction number 6. Okay, number 6. Number 6 is an instruction that you would rely on if you found that he was not guilty of committing assault in the second degree, okay? This is a lesser degree of assault. This is assault in the 4th degree, okay? And I'm going to tell you right now, and you can see it in the instruction, the only difference here is that instead of recklessly causing serious physical injury, okay, it simply states that he caused physical pain. Now, you heard from that young lady and you saw her. That is, without question, serious physical injury. This instruction does not apply here, okay? Let's go on to the next instruction. Instruction number 7.
1 minute.
Thank you. Now we're talking about armed criminal action. We touched on this in jury selection, okay? First, you have to find him guilty of assault in the 2nd degree, okay? Once you've done that, you now go down and you consider instruction number 5. And what you're doing here is you're finding that the defendant committed assault in the 2nd degree by, with, or through the knowing use or assistance or aid of a dangerous instrument, okay? Here's the definition for dangerous instrument. It means any instrument, article, or substance that under the circumstances in which it is used is readily capable of causing death or other serious physical injury, okay? We know that cars are dangerous instruments. Thank you, Your Honor. We know that deaths occur from motor vehicle accidents. We know that Janae Edmondson lost her legs by being crushed by a motor vehicle that was driven, I believe Mr. Edmondson said, like a 5,000-pound missile. That's how it was coming down the street towards them. That is a dangerous instrument, without a doubt. You're going to go to the verdict form for instruction number 5. You're going to have the foreperson sign guilty on armed criminal action, okay? Then the next 2 counts are essentially identical, only we have different
I think her time is up.
victim names in there, okay? This is assault in the 4th degree, and this instruction is regarding Elizabeth Smith, and instruction number 9 is regarding Markia Gorman. This is assault in the 4th degree, which is that the defendant recklessly caused physical pain to each of these ladies by causing a collision with the motor vehicle in which she was in. Okay, we know that. They had physical pain, fortunately not even close to what Janae endured. But we know they had physical pain. They had to go to the hospital. They got checked out. You're going to go to the verdict forms for 8 and 9, and you're going to have the foreperson sign on the guilty form, okay? Finally, the last one is that instruction number 10, that the defendant operated a motor vehicle on a highway in the 1000 block of St. Charles. He did so during a time when he did not have a valid operator's license, and that he knew or was aware that he didn't have a valid operator's license. Then, if you've met those elements, which we've checked all the boxes, you know about the record from the Department of Revenue, no driver's license, okay, no, none. Then you're going to go to the verdict form for instruction number 10, and you're going to find him guilty, okay? Now, Mr. Deemer is going to have an opportunity to speak to you, and then I'll get the last word because we have the burden of proof in this case, all right?
Mr. Deemer?
Can't wait to hear what he gonna say.
Thank you, guys. It's been difficult. We appreciate your attention. At the very beginning of this case, when we were selecting the jury, I told you there was no doubt about serious physical injury. A lot of emotion wrapped up in exactly what happened. When she lost her legs tragically, horrifyingly, that night, it put a lot of emotion in this case. But emotion is not mechanics. Emotions are not evidence. You have to concentrate on the evidence in this case to arrive at your verdict. They have to prove that Daniel knew that his actions were certain to do this. Not that they could, but that they
You're
will
right, John.
result. Not that they could result, that they will result under that instruction. To consciously disregard a substantial and unjustifiable risk that circumstances exist that will result. How do we know that that is a very difficult equation? Well, first of all, the same action in running the yield sign and speeding did not cause serious physical injury to Elizabeth Smith, nor to Micaiah Coleman. Well, if he knew that his consequences in driving that way were certain to cause that effect.
Your Honor, I'm going to object to misstating the instructions.
Please read the instruction. The word will is in there, not may. It is will cause. Right? Follow that logic. And what happened was, 2 people got injured. They were hurt. The car, nobody knows how fast or how much energy that it was going to take. The car was lifted in that collision. When Daniel lost control of that car at that point, did he will it into somebody? Nobody wills that. Nobody wanted anybody to be hurt that night. Daniel didn't want that. Was he being a knucklehead? Maybe. Was Elizabeth Smith speeding? You know, we have to ask ourselves that question because we don't know. Because of the police work that has been done in this case, we do not know what she said. Her body cameras were on when they talked to Elizabeth. Nobody really knows how fast she was going. She doesn't remember how fast she was going. So we're going to rely on this box thing. We'll get to that in a minute. But the scientists, the evidence testimony is to make sure that box is even right. She doesn't know her speed. The woman doesn't know. We do know this, that the woman with decreased vision never touched her brakes and hit that, and look at the pictures, with enough force to throw that Audi onto one wheel when Daniel could no longer have control of that car. And by golly, by gosh, I wonder what Daniel knew about her when she was driving down the road. Did he know that some of those circumstances were, she shouldn't have been on the roadway either? Did Daniel know that there was a car that was parked against a yellow curb and that when she hit him with enough energy, it was going to spin him into a car and crush this woman? How was he going to know that? How was he going to know that those
Shouldn't have been driving fast, no way.
that result would necessarily follow? Again, look at the evidence in this case. What they needed to prove to you is what Daniel knew. They're trying to tell you that, oh, he must have known because he was so blasé. No, they didn't use the word blasé. Everybody wanted to say he was nonchalant. I wonder if and how they all chose that word. It's interesting that they all chose that word, that they were consistent in using that word. But was Daniel blasé? No. What did he do after this accident? We had to find out from Micaiah that he actually came back. He came back to check to see if they were okay. That's what he knew. He knew he had been in an accident. And what he did was what a reasonable person would do. He went back and he checked on that.
Well, that's good.
Did Daniel know that somebody was hurt there? No. Did somebody tell him later? Yes. Did you hear one police officer come in here and tell you that Daniel knew that it was his car that crushed her? Any police officer? One. More than one? No. Daniel has been cordoned off and shut off from the world. He had to borrow a phone from a stranger who doesn't appear in the report until much later. He had to borrow a phone from a stranger to get a hold of his mom and let him know, hey, I've been in a car accident. Can you get out here? I just, ripped the car. Whatever. He had to get a phone to do that. Okay? And then eventually they arrest him and they kind of cut him off. And he's like, I've been cut off. And they're making a big deal about him worrying about a phone. That's a critical situation because he doesn't know what's going on. No one has told him, other than a girl was hurt, how, in fact, she got hurt. He knew it was an accident. Nobody said, hey, Daniel, your car is the one that hit that pedestrian. So when you ask him about being nonchalant, he is being told this entire time that he's doing 60 or 70 miles an hour. It may have been his perception that he was going slower. Maybe he was going faster. But it's his perception, and he did. Even the physical evidence. The EDR said he actually slowed down a little bit right before he hit that yield sign. A yield sign, by the way, that doesn't say cross traffic does not stop. What's in Daniel's mind when you see yield and cross traffic does not stop? Something completely different than yield. They're trying to say,
Objection as to speculation and subject to our motion.
That's his closing argument, though.
all I'm saying is that signs give people information. Did Elizabeth Smith have a sign that warned her of perhaps a blind alley? That's what this is about. Consciously disregarding the substantial and unjustifiable risk that it will happen. So Elizabeth Smith, was she able to control it? Maybe, maybe not. I don't know how fast her car was going, but look at the front end of that thing. We got Travis Jones here to try and tell you guys that she might have been going a little bit faster. None of their experts want to tell you exactly how that Audi became airborne, other than maybe it was too stiff at that point, or some sort of mechanical nonsense. It's a car lighter than the Audi that sent the Audi into outer space. He got hit, not with a little bit of force, but he got hit hard enough that he blacked out. And when he kind of sort of came to, he checked on people. He didn't know he had hurt her. So here's the thing. When they're saying he didn't have any emotion, the emotion comes from knowing. You guys know what happened. That is the emotion of things. Daniel can have no emotion for things he does not know. So to ascribe an emotionless Daniel to this situation is just wrong. And what witness came in here and said, oh, by the way, he was, high, and therefore he didn't know? No, that whole fentanyl coating thing is a distractor. They're saying he's a bad guy. He's made bad choices in the past.
They didn't say
That's what
that.
that's about. It's not whether or not he was high, because you heard not only
He was high.
science, but Mark said, if this kid had been screwed up that bad, if Daniel had been screwed up that bad, don't you think somebody would have said, how do I think? Can you step heel to toe, done something to verify that maybe he was high? No, it was just lucky they found out maybe he did something stupid, but we don't even know if it was him. I mean, you look at Chapo, okay, who doesn't wear his body camera conveniently when it's not the defendant on film, when they want to concentrate every what disappeared in the Leica? A car that was on the scene? Wait, we're going to trust his measurements now, who doesn't even put a 4,000-pound car in the picture under the yield sign, right there at the corner. Completely missed. Put that out of there. We're going to say this is his view and this is how fast he's going. Oh, wait, those measurements about that car and where everything was provided by a Leica. I don't know what that is, but it was Moran that was using it. And if it's Moran's information that went into that, what happened to that car? Are those measurements accurate? So when they're sitting there telling you how fast he's going, they need witness statements to say, well, she said she was 45.
Well, she don't have no legs.
45, and the distance covered by the Leica is 45. What they don't have is a statement by her speed.
I'm going to skip him a little bit because he kind of like upsetting me.
Cut once. That it. And return your verdicts appropriately. Thank you.
Gee, thank you.
What is she doing now?
Why would Mr. Riley use the truth on the law? All right. Focus on what the law is. That's in.
I'm ready to get to. I'm ready to get to the real nitty gritty. That's what I'm trying to get to. Um,
Smells like grapefruit. Cleans like
to
Clorox. Feels like paradise.
If you paid more than $50 on tax
hold on,
preparation
y'all.
last year,
I
you
want to
visit
hear the
pre-tax.
verdict. I kind of
First, we go to
know.
the
Wait,
Hamilton
hold on
County.
for a minute. I kind of think that I already knew what it's going to be. I know he's going to be found guilty, but a little 17-year-old girl lost her legs because of somebody. Hold on, y'all. Okay, let me put it on right here.
But because of him and his recklessness,
Hold on. Cause she already. I want to get to the verdict. And you know, and I hate that this happened to this 17-year-old because she can't no longer play volleyball anymore.
something about this one.
Her career is over.
You should do something about this one. I implore you to do something about this.
And she told her dad to look out.
I'm going to show you State's Exhibit 170. That was Janae just hours before she was crushed in between two cars.
Look out, y'all.
Just hours before she was hanging on to life by a mere thread.
Yeah, both of her legs.
Show State's Exhibit 7, please.
I'm not gonna show the car.
This is where high school. She's having to clean her horrific, painful wounds. She's had to endure unimaginable pain. She's had to endure, she told you, those phantom pains where she gets tingling and she thinks she can feel her legs. She's had to have therapy, the cupping and holding, where her parents have to touch each one of her legs and say, these are your legs now. These are your legs now. Because her body and her mind can't accept it. This is her reality. These are the consequences she suffered because of his actions. Now, it's important that you send a message to the defendant that he's got to suffer consequences for his actions too. Okay? This isn't a just walk away and forget about it. Well, remember what he said? She lost a leg? Oh, but she's still alive, right? Okay? He needs a reality check. He needs a reality check. Because from what we've heard about his behavior that night, he was entitled, selfish, and reckless young man. We can't have drivers like that in our city. Take a stand today. Are you going to stand with what's right?
Objection, Your Honor. This is improper.
Or are you going to stand with the defendant?
I'm going to object, Your Honor, that is improper.
Do the right thing. Find him guilty, all 5 counts. Thank you.
Now, the thing
Smells like
what
grapefruit.
they had, the
Cleans like
verdict
Clorox.
came to that I want to show. I don't want to give it away. I want to tell y'all what happened. I want you to hear what this is right here.
I felt something hit me. Well, I heard my dad screaming, and
Well, I showed y'all. Hold on. This is the verdict. Okay, let's look at this.
Good morning, Michelle and Rennie. Daniel Riley served nearly 19 years in prison. Just before 6:30 last night, a jury found him guilty on all but one misdemeanor assault charge for causing the crash that has changed Janae's Edmondson's life for good here. Now, take a look at this video from the courtroom yesterday. We really could not see his reaction as the verdict was announced. He wore a mask in court. Riley's family was pretty shaken up as it happened with one person leaving the courtroom. Edmondson's family, on the other hand, were relieved. In their absence, Janae's 3 siblings left a heartfelt message, which was read by prosecutors.
If you had asked us 1 year ago if we had anything to be grateful for, we would have said no. But today we stand together eternally grateful that Janae is still alive. We are grateful that our dad was able to utilize his military training to save her. We're grateful that Janae found the strength to adapt to her new life.
Now, the judge will have the final say on Riley's sentencing. That hearing is scheduled for April 18th. And we will also find out on that day if the sentencing will be held concurrently or consecutively, if he will serve that time out then. And then, as for now, the defense has 10 days to appeal. Live downtown, Travis Cummings, 5 on your side.
Okay, y'all. So y'all heard that on April. We'll be back here on April the 13th. But he has been found guilty. Okay. And I hate that the young lady had to go through this, but she's still, I hate, she was 17 when this happened. So y'all like, share, and subscribe. And I'll be back in April the 18th to let y'all know what the judge say. Okay. I'm out.